Good morning.
Good morning. Do you want to know what is labor relation?
Yes, what is labor relations?
Labor relations refer to the dynamic interactions and negotiations between employers, employees, and their representatives, often including labor unions or other worker advocacy groups. At its core, labor relations encompass the complex web of relationships, policies, and practices governing the employment relationship. Key points in labor relations include collective bargaining, which involves negotiations between labor unions and employers to establish terms and conditions of employment such as wages, benefits, and working conditions.
Labor union serves as representatives for workers in negotiations with employers, focusing on collective bargaining to improve wages, benefits, and working conditions. They provide members and legal financial support while advocating for worker rights and social justice. Employees in labor relations is collectively bargaining for their rights, engaging in union activities and advocating for workplace benefits. They come in various forms, including full-time, part-time, and temporary workers, unionized and non-unionized employees, as well as skilled and unskilled laborers, each contributing uniquely to the landscape of labor relations. Employers shape labor relations by establishing workplace policies, managing employee interactions, and advocating for management interests during negotiations. They vary in form, ranging from small business to large corporation government agencies, each holding distinct approaches to labor management and negotiation strategies.
During the Industrial Revolution, workers began demanding better treatment from their employers as they witnessed harsh working conditions, long hours, and low wages in factories and mines. With the rise of urbanization and the shift from agrarian to industrial economies, workers organized movements and protests to advocate for improved working conditions, fair wages, and shorter workdays, leading to the establishment of labor unions and implementation of labor laws aimed to protecting workers' rights. So there are different types of labor movements. Labor movements have been marked by key milestones including the formation of labor, which workers' collective bargaining power, labor strike, where workers protested for better working conditions and fair treatment, legislation and labor laws, which were enacted to protect workers' rights and ensure safe workplaces.
The Railway Labor Act of 1926 provided a framework for labor relations in the railway industry, emphasizing negotiation and arbitration to resolve disputes. The Norris LaGuardia Act of 1932 restricted the use of injunctions in labor disputes, protecting workers' right to strike and organize. The Wagner Act of 1935 promoted collective bargaining and established the National Labor Relations Board, while the Taft-Hartley Act in 1947 added regulation on union activities and prohibited certain unfair labor practices. The Landrum-Griffin Act of 1959 further regulated internal union affairs, aiming to ensure transparency and democracy within labor organization. The Norris LaGuardia Act of 1932 facilitated union organizing by limiting the use of injunctions, ensuring employees could engage in such activities more freely. It established procedures for fair hearings in labor disputes and granted workers collective bargaining rights, enhancing their ability to negotiate with employers for better working conditions and wages.
Next is the Wagner Act or the National Labor Relations Act. It is a crucial law in the US that protects both workers and employers. It encourages them to negotiate together and establish the National Labor Relations Boards to ensure fair practices. Next is the employee rights. Employee rights are encompass fair pay, safe working conditions, freedom from discrimination, privacy, freedom of speech and association, protection from retaliation, and the ability to take family and medical leave. Next is unfair labor practices. Unfair labor practices are actions by employers or unions that violates the rights of employees protected by labor laws, such as discriminations, retaliations, interference with union activities, or refusal or bargain to collectively.
What is union security? Union security is a rule that says workers on a certain job have to join a union or pay money to the union so they can keep their job. So there are different types of unions, the union security arrangement. So close shop. This is a workplace where the employer can only hire union members. Non-members cannot be employed. Second is modified union shop. In this arrangement, Non-union members can be hired, but they must join the union within a certain period of being hired. Union shop. All workers must join the union within a specified time after being hired and maintain their membership as a condition of employment. Maintenance of membership. This means that the workers who are already union members at the time the agreement is signed must remain members for the durations of the contract. However, new employees are not required to join the union. So, national government agency for employee union and representative. So, national government agencies, these are the government departments or offices that the national level, like the Department of Education or Health. Employee, next is local government units. These are the local government bodies like cities or provinces with their own officials and laws. Government-owned or controlled corporations or GOCC. These are the companies that are owned or controlled by the government but they operate like private businesses. So the rights of the legitimate labor organizations in the private sector based on the Article 242 of the Labor Code of the Philippines. So undertake activities for members' benefit. Labor organizations can do things to help their members. So they can take legal action or be taken to the court. Exclusive representative of all employees. They are only ones who can negotiate to all employees. Represent union members. They can speak for their members in work matters. Here are the rights of the union members or the members and employees organization according to the Article 241 of the Labor Code and Rule 3 of Section 1 of Executive Order 180. So this refers to the right to participate in union activities, including voting in union elections and referendums. Deliberative and decision-making right. Members have the right to participate in discussions and decision-making process within the union, such as meeting and so right over money matters. This includes the right know how the union funds are being used and to participate in decision regarding to use the union funds.
Today I report my topic, employees' rights to self-organization. So, to reform and join assist labor organization for the purpose collective bargaining to the representative of their own choosing. So next is to engage in lawful concerted activities for the same purpose for their mutual aid and protections. So this means that it refers to the ability of workers to join together to form labor organizations for the purpose of collective bargaining, which is negotiating terms and conditions of employee with their employer. So this means that this includes forming labor management committees, work councils, or other forms workers participation schemes to aim and achieve goals and objectives. So for example, employees working in a government agency may decide to form labor union to address issues such as workplace safety, job security, and fair wage. So next is the collective bargaining represents to its process where the representative of employment negotiate with employer to reach agreements on working conditions, benefits, and etc. So for example, a teacher union negotiate with the school district for better salaries and improved working conditions. So that's all.
Bargaining strategies. Several approaches used to negotiate deals agreements between parties. Next is distribution bargaining, a competitive negotiation approach where parties try to minimize their own gain, often resulting in a win-loss outcome. Next, integrative bargaining, a collaborative negotiation approach where parties work together to find solution that satisfies both sides' interests, aiming to win-win outcome. Next, in interest-based bargaining or IBB, negotiation approach focuses on the underlying interests and need of each party rather than position, aiming to create value and reach agreement beneficial to all. Next is consequences not all reaching agreement. The negative outcomes that occurs where parties fail to come to mutual understanding or agreement. Next is impasse, a deadlock on statement in negotiation where parties cannot reach an agreement of a conciliation. A process where a neutral third party intervenes to help to dissolve dispute or conflicts with the parties, often facilitating communication and finding common ground. Next is mediation. A voluntary and confidential process where a neutral third party helps parties in dispute reach mutual acceptable agreement does not impose a decision. Next is arbitration, a process where a neutral third party called the arbitrator listen to agreements from both sides and make final finding decision dissolve and dissuade. Next is trends and liberalization. Change in union activities involving strategies and approaches employed by labor unions in response to shift of economic, political, social landscape. Next is social media. The use of platforms like Facebook, Twitter, and LinkedIn to organize their community and formalize worker as well advocate from labor rights and cause.